Okay, good afternoon, everybody. My name is Bobby Link. I'm an attorney at David A. Gallo and Associates. Here with me today is my partner, David Gallo. We're here to talk about commercial leases and COVID-19, specifically issues pertaining to whether the COVID-19 emergency constitutes an impossibility of contract that somehow makes the rent not due or would give you an opportunity to renegotiate your rent with your landlord. We're also going to be touching on some Chapter 11 bankruptcy issues, maybe some SBA issues, some pending legislation, the eviction moratorium, and some issues like that. We have a nice group here, and it's a nice size that, usually I like to save the questions for the end. That way we don't have too many audio problems asking questions. But if you do have a question, just unmute yourself and ask the question, and I'll take the question. If you don't want to unmute yourself for whatever reason, you could try to put it in the chat box, and I'll periodically throughout the presentation check the chat box. But hopefully we can get turn off my fan. Hopefully we can get a nice dialogue going today about the specific issues that you're running into. This is your hour. This is not our time. This is your time. We want to make sure it's used to the best of your ability, and we really have a nice, robust conversation. David, anything you'd add to that?
Yeah, just a little background information about the firm. I'll just talk for a minute, and then Bobby. I've been practicing for about 40 years. Our office for a long time was in Queens, Rego Park. We moved out here about 3 years ago. My background is in commercial lease litigation, foreclosure, landlord-tenant, residential and commercial litigation, the related bankruptcy, and character and fitness issues. I've been a member of the Character and Fitness Committee for the Second Department for about 25 years, having been appointed by 3 presiding justices of the Appellate Division. I'm also a special master at the Appellate Division, handling mediations there. I've been on the Housing Court Advisory Council, dealing with the appointment of housing court judges for 9 years. And so my overall experience for the last 40 years has been in the area of default services and commercial and residential leases.
And again, my name is Bobby Link. I've been an attorney for about 10 years. My experience is in real estate litigation, specifically foreclosure, eviction. I represent a great deal of commercial tenants in lease renegotiations. We've handled some holdover issues, some issues where the landlord illegally used a portion of the space and we had to seek an abatement. Yellowstone injunctions where the landlord seeks to terminate the lease for failure to comply with a legal requirement. But mainly I'm a courtroom attorney. That's my background. And I just wanted to say thanks to Will McCarthy. I'm not sure if Will, are you on the call? He's of the Corona Plaza Business Association or the Business Alliance. And, thanks a lot for setting this up. And again, fire away with any questions whenever you have it. But I wanted to start with New York Pause because there's a lot of contradictory information out there with respect to the eviction moratorium. There was an eviction moratorium through August, and then it was extended very recently. There was actually a couple of weeks there where firms were allowed to file eviction papers, and some of you might have even gotten some eviction petitions. Those cases aren't likely to be scheduled in the courts anytime soon, but for right now, Governor Cuomo has issued an executive order that is being interpreted to stay evictions to the date is September 4th. So in this time, you might get an eviction notice. You might get a petition that says you have to show up to court. You should treat that seriously, but as a defense, you probably won't, but as a defense, I would say that there is a moratorium in effect right now, or certainly you can make an argument that there's a moratorium in effect, and that is through September 4th. and that's based on Administrative Order 20255, which was issued just a week ago. So that's the latest. The courts are, of course, interpreting that. The way I am not personally, I'll start like this. I am not personally expecting a great deal with respect to evictions in the year 2020. And the reason why is you're seeing right now not a whole lot of activity in the landlord-tenant part. There's legislation pending to even push the moratorium further through the end of September. And I think even once the courts get going somewhat, they open the door a little bit to start to take some petitions. It's going to be very slow going. They're going to want to focus on the cases that were pending on the calendar before COVID-19. So cases, that had issues earlier in the year, they're going to focus on those cases first and then handle new non-payment cases, new holdover cases, and start to widen the door. But if you've ever been to landlord-tenant court, the design of the court is that lawyers like David and myself are out in the courtroom hallways, tightly packed together, appearing on calendars with sometimes dozens of cases, maybe up to 100 cases on a calendar, stuffed in a courtroom. And this was before, something like a quarter to a third of businesses and tenants aren't paying their rent, and there's going to be many landlord-tenant disputes. So we're increasing the number of litigants that are going to be put into that building substantially. At the same time, where we have to respect social distancing and whatnot, it's going to be very hard to just set up Zoom conference calls to allow everybody their day in court and their proper due process. So at some point, they got to open up the courts. It's going to open up slowly, and I wouldn't anticipate that to happen until early next year at the earliest. David, anything on that?
You covered it pretty well. The only thing I might add is that what it looks like is going to happen is on non-payment cases, residential and commercial, if the tenant can demonstrate COVID-19 injury, that the courts will award a money judgment for past due rent, but not a possessory judgment. At least that will probably be in effect until the end of the year. And in the case of commercial tenants, there is a bill out there which potentially would allow a tenant to demonstrate COVID-19 injury, can demonstrate an 80% reduction in revenue, and hence perhaps be entitled to an 80% abatement in the rent versus the forbearance in the rent. That bill has not passed. However, there is plenty of law, common law, many cases in common law versus the statutory scheme where that type of relief may be open for a tenant suffering from this unforeseen pandemic. So I would agree with Bobby that there probably are going to be very, very few non-payment evictions this year, if any at all. However, on the other side of the coin, the holdover cases where the landlord is not suing for rent but is suing for possession of the premises, I think that will start to open up in September and through the end of the year, albeit very slowly, because think about it, nothing has been really going on since March, and thousands of cases are typically filed every month. So now you have all the cases that would have been filed. You have the landlords contacting their attorneys. I want to start these cases. When's the soonest we can do it? So you're going to have You're going to have about 5 months worth of cases trying to get into the court system in a very short time, plus the thousands of cases that you had pending needing adjournment dates. I think landlord-tenant court, of all the different litigations that occur in New York State, I think that is going to be a real issue to navigate over the next year.
I agree. That's an important point. The difference between the holdovers and the non-payments. So with that information, now you want to think about what's your strategy, what's your business strategy for the rest of the year and into 2021. And you want to think about, what can I afford as my business? What kind of defenses might I have? What does my contract provide? My lease contract provide to remedy this situation. You want to think about the timeline for eviction. You want to think about the likelihood that your landlord is going to get a new tenant, and you want to think about your relationship, your existing relationship with the tenant. Are they someone you can talk to and explain that, hey, I'm a dance studio and I can't open my dance studio right now or a gym because it's illegal to do so. You have to work with me here. Let's work together so we have a plan where I can make the right accommodations to be ready in 2021 when things open back up again, and you'll be in a position to have a good tenant that is going to be able to pay your rent as soon as things open up again. So you want to start thinking about these issues now. I think it's best to reach out to your landlord right now and try to at least make some headway with these initial discussions. That way you can properly plan your business and not just put it off. Some potential resolutions that you want to kind of be thinking about in the back of your head. Number one, there is a rent forbearance, right? Rent forbearance means, okay, the contractual sum of rent, let's say you pay $20,000 a month for the rent. It's still due, but it's just not due right now. It'll be due later. Maybe you have in year 6 of the lease some rent forgiveness, some months where you had negotiated when you started the lease contract. You had some free months in, I don't know, April of 2023. Well, maybe we could renegotiate the lease in a way where those payments will be due, that you're forgiving now will be springing up later on in the lease when you'll hopefully be able to pay it. The next option is you'll have a rent abatement. A rent abatement is when the rent is forgiven or a portion of the rent is forgiven. So we've seen situations in bankruptcy court, for instance, where we had a restaurant, and this is an Illinois case, you had a restaurant where the landlord sued in the bankruptcy proceeding to get the full amount of rent due, and the tenant said, well, I only had access to if you're not speaking, make sure to keep your microphone muted. In the Illinois case, the tenant said, well, I'm operating a restaurant. The state of Illinois has said that I am not able to operate at full capacity and have people actually inside dining in. So I'm really only using 25% of the restaurant, which is the portion that's, making the cheeseburgers or the pizzas or the steaks or whatever you're serving. So the court in that case, they crammed down 75% of the rent. And that wasn't because of some provision of the bankruptcy code. That was using common law principles of impossibility. And in that case, actually, there was what's called a force majeure clause in the contract. So let's go to that. Force majeure. David, anything you wanted to add to my summary there?
No, go ahead. I'll summarize.
Force majeure, well, when I say force majeure, and a lot of times we'll see force majeure, impracticability, impossibility used kind of interchangeably. But force majeure specifically addressed refers to a section in your contract in your lease contract that provides for what the parties' rights and responsibilities are when a force of God, an act of God, makes performance under the contract impossible. So, for instance, if you have a barber shop in Corona and Governor Cuomo has issued an executive order that says barbershops cannot function under the public health emergency, you would have an argument that, well, under my force majeure clause, there's a provision that says if I can't operate, there should be an abatement of the lease, or the lease won't be enforced. Well, in that situation, I shouldn't have to pay the rent because I contracted to have a barbershop, and the state of New York temporarily made barbershops illegal. You would argue in that context that you didn't get the benefit of your bargain. That's contracts 101, right? You bargain for something, you get something in exchange for that consideration that you've paid. So if your rent is again $10,000-$20,000 and you're not able to bring any customers in, well, then there's a question about whether performance was made impossible. In New York, it's important that if you have a force majeure clause in your contract, and you should solicit the assistance of an attorney to review it because they can be long, they can be complex, it has to specifically reference the act of God that is being implicated. Here, you would need a reference in your lease contract to take advantage of that force majeure clause to an epidemic, a pandemic, or a government forced closure. For instance, if the force majeure clause says you are protected and performance under the contract is excused in the event of floods and natural disasters and any other act of God, you wouldn't be able to go to your landlord, at least in New York state courts, and say, well, any other act of God, I mean, the pandemic epidemic clearly falls under that. It has to be specific. There's quite a bit of case law that says your force majeure provision has to be specific to the issue at hand. And here, again, you're talking epidemic, you're talking pandemic, you're talking about government closures. You're going to have to see that specific event. And because of that event, under the force majeure case law, performance has to be made impossible. So again, you have your barbershop, you couldn't open up. You have an argument that if you have a restaurant that can kind of temporarily open or only do takeout service, your performance has been made impossible. If you have a grocery store or a bodega that was open the whole time, you're probably not going to have a strong argument that performance was made impossible. Maybe you can make some arguments with respect to forced social distancing requirements or something to that extent, but it's going to be a much harder uphill battle. And the contract might actually require you to invoke the force majeure provision. So you want to look at it immediately. There might be a requirement that you have to tell your landlord in advance that, hey, I am invoking force majeure. It's in my contract. I am excused from paying the rent. That's why you really need to talk to an attorney, look and see if that force majeure provision is there. In many cases it is, in others it's not, and see what it provides in the particular circumstances. David?
Yeah, so even if the force majeure clause isn't applicable, you still have the common law case law that says if performance was rendered impossible because of the pandemic, that you don't have to pay your rent, or you don't have to pay a portion of the rent. So all is not lost. But just to summarize here, really I look at this webinar as hopefully facilitating, having people think about exactly where they want to go going forward, whether you're the landlord or the tenant. The last thing you want to be doing is litigating this in court, okay, because of the reasons we just said. The cases in landlord-tenant court are going to be so jam-logged, things are going to go nowhere. And you don't want to be part of that, whether you're the landlord or the tenant. What we have been doing in this office is we get a phone call from the landlord, we get a phone call from the tenant. The dance studio is a perfect example. We try to carve out a specific remedy that works under the circumstances of your particular case. We get in touch with your landlord or your landlord's attorney so that we can start the dialogue. I have one client of many. This particular one is a dance studio. They have a dance studio in one county. They have another dance studio that they just opened up. I negotiated that lease for them last fall. The dance studio in the one county, they've been there for about 15 years. What they were able to do was mitigate their damages. While they couldn't bring people into the studio, they started having online dance lessons. And they have a following because they've been in business for so long that maybe a third of their clientele continued to pay and have the dance lessons online. So we were able to negotiate a partial abatement and forbearance going forward for that particular studio, which works out for them, keeps them in business, helps the landlord because the landlord doesn't want to lose them. What are you going to do? Get no rent at all? Tell them, if you take a position, I either get all my rent or none of it, and the tenant says, well, you get none of it, and then the courts come down and say, well, because of this pandemic, they're entitled to a significant abatement. You know, you really haven't helped yourself, and maybe you've lost a very good tenant. The dance studio in the county that we negotiated the lease last fall, they didn't have the following that they had in this studio that they had been in business for 15 years. So we, you know, even though it's a dance studio, we had to carve out a different remedy, and there an abatement was a much more appropriate remedy for them. Because they didn't have the following, no students were going online with them. They didn't have that following of 10, 3, 5, 10, 15 years. They had maybe 2 or 3 students that had just started to take dance lessons with them, and then they went away because of the pandemic. So you've got to carve out the remedy. But the whole idea here is to take a look, whether you're the landlord or the tenant, take a look at your lease. What does the contract provide? Work within those parameters, and then to negotiate what is right for both businesses, either a partial abatement and forbearance, maybe a full abatement for a certain period of time. I represented a barbershop. You know, the business that he lost, he's not going to get back. People, you know, he's starting to open up again. And he said people are coming in with hair down to their shoulders. It's not that they're going to get twice as many haircuts as they did before. You know, and the same thing with the dance studio. They're not going to where they were taking 2 or 3 dance lessons a week. They're not going to start taking 5 and 6 lessons a week. Chances are the business that they lost, unless they were able to do it in a webinar type situation, that they've lost for good. As opposed to
that's an interesting point, David, because I'm thinking if you have a car dealership, and you were shut down in maybe March and April. Well, the people who were going to buy cars in late March and April, I mean, there was nothing stopping them from just selling more cars in May and June. So in those cases, the shutdowns were not as significant. Didn't hurt the business as much, and perhaps they were able to get more benefit of the bargain.
And that's a great example. We're representing a landlord that leases to a car dealership right now, and they're asking for a significant rent abatement rent reduction going forward, because they're saying we were really significantly hit by this pandemic. We didn't sell any cars for a limited period of time. But, they're starting to make it up now that they're allowed to do business. Furthermore, we're seeing that more people are buying cars because they have nothing to do and they want to travel. So the new car market has actually spiked, even vis-a-vis last year. So you have to really look at every situation and carve out the appropriate remedy to keep yourself out of landlord-tenant court. I would just advise anyone out there, don't wait until you've received the summons and complaint. Try to negotiate now. Be careful. I would recommend that you go to your attorneys to negotiate this, if this is what they do, because you want to be very careful. Any negotiation that you do enter into now, and any agreements that you do enter into now, you enter into during the pandemic, which means whatever remedy you've carved out for yourself, that's it. You've done this eyes wide open. No one, if the new deal you made today doesn't work for you in December or March next year, the court is not going to want to hear, well, the pandemic again. The court's going to say, no, the pandemic was in March. You made your new deal in August and September. You had the pandemic to think about. You made your deal. Maybe you didn't make a very good one, but we're not going to let you renegotiate it again because now the pandemic was a foreseen event. So you have to be very, very, very careful. What we're telling our landlord in this car dealership is, don't be too quick to jump at what they're asking for now, which is significant, about a 25% rent reduction. You're going to be stuck with this rent reduction for the next 10 years under this lease. This pandemic is going to be over in about a year and a half, and there are other circumstances affecting it. You have to apply that kind of logic to your specific tenancy, to your business. Whatever you negotiate now, it's eyes wide open. Don't do it wrong.
In my view, David, I think it's better to not have the force majeure provision. I mean, we'll see how this bears out. I think it's better to not have the force majeure provision, rely on the common law. That way you're not restricted to the specific language in the lease contract. Frustration of purpose, impossibility, you're merely showing that you had this unforeseeable event. And David, I think that was a great point, that the event is no longer unforeseeable if you're making negotiations after the fact in April, May, June, July, August, September, and then performance is rendered impossible. So you really only have to show those two elements. And I would argue, unless you're making new negotiations and you've reached out to your landlord and they've already made an accommodation for you, the unforeseeable event prong of the analysis should be easy to satisfy. I mean, this pandemic, at least the scope of this pandemic, was not foreseeable. This is not something that attorneys were thinking about when they were drafting leases. Oh, what happens if there's a public health emergency and the government, the United States of America, is shut down for 6 months? This is not something that we were thinking about when we were drafting leases. I think it's a pretty cut and dry, unforeseeable event. And I think the majority of these, I think you'll have some arguments that it wasn't unforeseeable, that we've had MERS and bird flu and the SARS and all these other epidemics over the past 5 years, and there have been warnings, by the CDC and the WHO and all these entities. But I think the prevailing logic is going to be that this was an unforeseeable event. The problem will become the second prong. Was performance rendered impossible, or were you able to do something? And I think it's going to depend in large part about how the judge sees the law. David mentioned before, there's some legislation pending that would bring some clarity to this doctrine. I hope it passes, but we haven't seen that go forward yet. David, anything you'd add?
No, just anything I would add right now on the topics we covered would be redundant. Be careful if you're renegotiating any contracts right now, because it's eyes wide open.
And kind of building on that, commercial tenants are sophisticated parties. What that means is, as opposed to the residential landlord-tenant context, in a commercial landlord-tenant context, a judge generally isn't going to go easy on you because maybe you didn't use an attorney when you negotiated your lease. Maybe you're a very small business and you don't view yourself as a sophisticated businessman, but the court views you as a sophisticated businessman. No matter if you're a small shoe shine shop or if you're a Starbucks. It really should matter. The court is going to look first and foremost at the black and white language of the lease, and they're going to stick to that black and white language of the lease, and they're not going to fudge any interpretation of that to give the tenant a break. By and large, that is the prevailing rule, that commercial tenants are sophisticated parties. Subchapter 5 of Chapter 11 of the United States Bankruptcy Code. This is important, and I'm just going to gloss over it because Subchapter 5 of Chapter 11 can be and has been its own webinar. But it's important to remember that in March, the United States Congress, under the CARES Act, they increased the threshold to take advantage of Subchapter 5 of Chapter 11. Subchapter 5 of Chapter 11 is important because it provides an expedited method for filing Chapter 11 bankruptcy that's efficient, that's much less expensive, and that allows you to get a plan approved over the objection of one of the creditors. So maybe one of your suppliers objects to the plan that you've set out to the bankruptcy code. You can get that plan to repay your debt approved over their objection under subchapter 5, where you can't in a general chapter 11. Right now, and up until March or mid-March, you can take advantage of, if you have less than $7.5 million in debt, take advantage of this subchapter 5 process. After March, unless they extend it, unless the Congress extends it, it'll revert back to the statutory debt limit of $2.7 million. So that is going to kick out a whole lot of businesses, larger restaurants, law firms. A lot of people are going to get kicked out if they don't file Chapter 11 in advance of March. So that's something to kind of keep in the back of your head. Bankruptcy can be a very effective option for dealing with your creditors, getting everybody in the same room, getting them to play ball, even articulating some of these arguments with respect to force majeure and frustration of purpose. David and I are working with a full-time. David and I have bankruptcy experience, but someone who full-time handles Chapter 11 bankruptcies, and that's something that we could review for you if you're interested. The purchase contracts, I'm not going to cover that. I wanted to skip to SBA assistance. I think most of you have probably gone through this. We're waiting to see if another round of PPP is going to be approved. I'm sure some of you would appreciate that. One thing about these loans is they're not personally guaranteed, and they could be, hypothetically, we're seeing how these shakes out in the court, crammed down in a Chapter 11 bankruptcy and paid like any kind of credit card or any other unsecured creditor. So that's something to keep in mind. You guys are mostly in New York City, so there are other New York City assistance programs. I'd encourage you to check that out as well. David, anything on the SBA assistance? I feel like there's a million webinars on this. I didn't want to talk about it too much.
Yes, and it really changes, and it probably will change again before the end of the year. They were talking about having to pay it back within a certain period of time. Then I think it got extended to 5 years, 1% interest. And now there's talk of allowing it to be paid out over 20 years. What's next? Maybe they're going to forgive it altogether. They're changing. They're changing. Used to have to use, I believe it was 80% of it towards employees, and now it's either 60 or 65%. A lot of you are probably saying to yourself, it still doesn't work for me. I get this PPP, and I've got to, even though they extended it to the end of the year, what's a factor in this is the number of employees that you bring back into your practice, into your business. And for many people, it doesn't pay right now to just start giving a paycheck to someone when you're still not operating anywhere near where you were before this pandemic. People are probably thinking, and should be thinking, in my opinion, I need to have cash in the bank. I don't know what's going to happen in September, October, November, December. I've got to, so I'm going to pay those people that are working for me that I absolutely need to keep my engine primed and keep the train on the track and moving forward and not backwards. But I can't bring everyone back, which may end up being very detrimental to you when you're going to deal with your bank with whom you got the PPP loan, trying to figure out what's forgivable and what's not forgivable. My advice is do what's right for your business. Worst case scenario, portions of it is not going to be forgiven, in which case you have a 1% loan, which is found money, over perhaps as long as 20 years, but at least 5 years, it looks like, unless they change it again. And there will be many changes. So I just, you've been in business, some of you probably for a very long time. use the same wisdom that's kept you in business this long to know how to spend the PPP, what's best for you, and just keep lobbying your congressmen and senators and councilmen and women and assembly, for what you need. They're all listening right now, and which is why the programs keep changing and the payback keeps changing, because they know they don't have it right yet. Don't sit back and be quiet. Tell them what it is you need for your business. They hear it enough, and it will happen.
We got some time, but I wanted to talk about legislation. You know about CARES. We've talked about what's going on at the federal level, and we're waiting to see what the next steps are, if something is going to get done in advance of the election. In Albany, the legislative session was supposed to be completed in I think it was June 4th was the last day. They passed a law that allows them to meet via Zoom and pass legislation. And what ends up happening is there's a couple of Democrats and a couple of Republicans that go up to Albany, and there's a couple of people there live who kind of say, "Oh, the Democrats vote in the affirmative. How does the minority vote?" And they'll say the minority votes in the negative, but if anyone wants to detail or change their vote, just contact me and we'll change it after the fact. So they're taking a very relaxed approach to just being able to pop back into session whenever they want to and pass new legislation. They have not technically concluded this legislative session. So you might see some legislation that helps small businesses. Really, in my view, they haven't done a whole lot to help small businesses yet, and I think one of the reasons why is because there's a revenue problem. So the state isn't going to have the revenue to do any kind of bailout program or anything like that. What you might see is similar to what they did in the residential context, where they said, David touched on this before, that was Senate Bill 8192B. They said the landlord can bring a non-payment and get a money judgment, but they can't actually evict you. They've done that in the residential context. Let's see if they expand that or try something like that in the commercial context. It hasn't been done yet. There's other legislation saying that personal liability in a lease will be waived in certain situations. So maybe you have a good guy clause in your lease that says you're on the hook, personally liable for a few months. There's legislation dealing with that. We'll see how that turns out. There's other ideas out there about using the security deposit and using that to pay down the arrears. There's also legislation that requires landlords, traditionally in a commercial landlord-tenant relationship, if you give up your business in year 6 of the lease of a 10-year lease, you still owe the remaining 4 years. Like I said before, commercial tenants are sophisticated parties, and they're going to hold that contract up. This bill, which has been approved by at least one house, would say that the landlord has to make good faith, reasonable efforts to mitigate their damages and try to re-let the premises, get a new tenant in there so you're not on the hook for the entirety of the lease. They actually have to try to get somebody in there and make reasonable efforts. So that's some of the things, the ideas that are out there. Hopefully the legislative session will come back. Probably my prediction would be the week after Labor Day, and work for a week or two and do something to help. But right now, they're not doing a whole heck of a lot for small businesses. They're kind of in a wait and see approach about what's going to happen and assessing the damage. David, anything you'd want to add to that?
No, you've summarized it. I think we should open up for questions since we're closing in on 3 o'clock.
Okay. Who has some questions for us?
Yes, sir. Mr. Angel?
I just sent you a message to unmute. Okay.
Okay, all right. I entered a lease in Manhattan, a small office, and everything was fine, was paying until the COVID-19 came. And the lease was a clause saying that if I want to vacate the rental, I mean the space, I have to pay them 2 months in advance so they can say, okay, the lease is over. So we didn't comply with that one, but since this is a school, the revenue was coming from the students, and the students they stopped coming. And also, the mayor of the city of New York states is no classes until September. For us, it was not really a good idea to keep the office there. What we did is on the end of March, we sent an email to them saying that we're going to vacate the space and take it from there. Now they are every month they're adding the money that we owe them. Now it's almost $3,000, saying that if you don't pay, we're going to, like on black market, we're going to send to report to different companies, so your name is going to be screwed up. So is anything I can do, even though I sent an agreement to them, in lieu of have a good recommendation, good an agreement, I said, listen, make me an offer which I cannot refuse, and we can work together, because as soon as the class is open, I come back again to the classroom. But unfortunately, they didn't do anything, and they say, well, read the contract. But now, is anything I can do, because the classes was going on okay, but now it's a stop to the COVID. What are my remedies if I have to go to court?
Well, so let me, Bobby, you want to start?
Well, I was going to say, what exactly is the business? It's like a tutoring service or something like that?
Yeah, it's a school licensed by the New York State Education Department. It's a private school. Just we began classes.
So it's a private school. Schools were canceled by the state of New York. And you have a regular lease with a private landlord.
Yes.
And how long was that lease in effect?
Every year we can upgrade it. It's no problem.
When does the lease expire?
Expire more or less, I think so, in February, a month before.
Okay, so you had a lease. So you most recently in February of 2020, you started another 1-year lease.
Yes.
Okay, and then after that, COVID hit. And now you're open back up now?
Well, no, I closed the office.
You completely closed the office, and you sent a notice, you said, to your landlord saying that you were closing.
Yes, I sent an email saying that I will be closing the office, I will vacate it, and
and they didn't accept that offer. They sent you some sort of other offer, you said?
Yes, I told them to give me an offer, and they said, well, I can give you 30%, no discount, but 30% reducing the money, but at the end you can pay whatever is the amount, but at the end, when everything is fine, you're gonna pay us the 30% back.
Right.
So they weren't willing to abate any. They just wanted to forbear from collecting it until the end of a certain period of time. But you said, I heard you say that they offered to let you out of the lease if you paid 2 full months.
Yes, and the lease, the contract says, if I have to vacate the office, I have to tell them 2 months of anticipation so I can live without it. But and that also in the same clause says that I have to pay them 2 months in advance in order for me to be off the hook, which actually they will have 2 months already security plus 2 months of rent in advance. They will have 4 months. And unfortunately, but now I'm learning from other spaces who is there. The landlord doesn't return any money at all to these guys. So they are losing more than they're supposed to lose.
Well, look, you could go back to them and say, look, take the 2 month security that you have as the 2 months, and I'll sign an agreement. Here's the premises back, and at least you know the limit of your liability. that you've lost 2 months rent, you're out of the lease for the remainder of the year, and then when things open up for you again, maybe they would consider taking you back. They do understand what's going on. What else are they going to do? They're going to put another school?
I mentioned exactly what you said. I mentioned them. I wrote it another email saying, I know I have to pay according to the list 2 months in advance, but you have 2 months of rent with me. So why don't take that money and I'm off the hook? They don't want to do that because the lease is signed in the name of my partner, which is there. And now the amount was $1,200, now is almost $4,000, and they're keep increasing. They don't want to accept anything else. So they want to damage the reputation, of my partner, and they don't want to deal. They don't want to negotiate. The only things they want the money, comply with them. Now they are saying, pay since March, April, May, June, July, pay the 6 months ahead, and we will terminate the lease. So I want to pay 6 months ahead for the months that they were over, plus 2 months security. I want to pay 8 months to them. So now they want to finish the contract, but when I want to get the money? These guys, I didn't know that they were.
Have you surrendered possession already? They have the keys?
Yes, I surrendered. I have give the keys. Everything is done.
And your partner is personally on the lease?
Yes.
Okay. Well, look, the only option they're giving you right now is to pay 8 months rent.
That's not an option.
And that's not an option. I mean, that's not really.
How I want to pay 6 months rent? 6
Right.
months, but 8 months. It's impossible.
Right. So your options are either to pay them what they want, or to not pay them anything, or to offer something in between. It sounds like they're not going to go back to the 2 months plus the 2 months security, 4 months that they were originally at. I think at this point in time, since you've turned over possession to them, my advice right now would be just to sit tight. And if they do sue for the 8 months, 10 months, that you use COVID-19 as your defense, that this was something totally unforeseen. I'm a state chartered school. The state shut me down. This was an unforeseen event. I was not able to mitigate damages, and I owe you nothing.
And I would
Exactly.
I would also counterclaim for your deposit back, because it sounds like you have a deposit, right?
Yeah, 2 months deposit. I have it.
Right. So you want to ask for a counterclaim for the return of your deposit, and that'll be some leverage. Counterclaim for attorney's fees. I don't know what your contract provides. The lease will provide in certain situations that the commercial tenant, if you're the victorious party, if you're the successful party, you're entitled to attorney's fees for reimbursement of reasonable attorney's fees. If it only provides that the landlord gets reasonable attorney's fees, that's not viewed in a commercial landlord-tenant relationship as reciprocal automatically. It'll only benefit the landlord, but that's something you really want to get familiar with the provisions of your lease and understand how that's going to work out. But I think you have a pretty strong case, at least the way you explained it. And, with the hypothetical that we haven't reviewed your lease, and it sounds like you have a good guy clause, we want to take a look at that good guy clause and see specifically what it provides. The duty to mitigate, you also want to watch for the legislation in the assembly that I believe passed one of the chambers that says, do I have it? Take a look at, it's Assembly Bill 10444, Senate Bill 8351, which provides, speaks to personal liability provisions of commercial leases when it involves the COVID-19 period. Take a look at that and the status of that. That's something that, I was monitoring the last time they were in session. There's a chance that the legislature could do something in the next month that addresses your specific situation.
Yeah, just last week I sent it another email saying, listen, there is a very terrible situation that we live in. You losing, I'm losing. So let's make a deal. You have the 2 months and that's it. That's the end. And I made it very clear to them, when everything comes in place, I will come back to take the same place if you didn't rent it. If it's not, I will wait for another time to come. But they don't want to listen anything. It's just they want the money back, the money. I say, listen, the state shut me down.
Right. No, I think you have strong arguments, at least the way it's been explained. Does anyone else have any questions on the call? Thank you. Anyone else have any questions? We still had a few minutes if you want to interject. Let me check the chat. Maybe someone hit us with a chat.